Last week, India's Vice President Jagdeep Dhankar, who himself has been an eminent lawyer, spoke on the contentious issue of judicial appointments. Well, we know that there is an ongoing tussle between the government and the Supreme Court collegium over judicial appointments in our country. The argument of the Vice President went far beyond who has greater say and power in judicial appointments. The Vice President attacked the basic structure doctrine that was formulated by the Supreme Court to a great extent. This doctrine was the basis on which the NJAC was struck down. Now, has the court usurped the powers of the parliament, as alleged by the Vice President? Is the allegation that the basic structure doctrine is merely a judicial creation has any basis in law and judicial history? We'll tackle all these questions. Hello and welcome to this edition of Let's Talk Law. I am Anusha Soni. Today we talk about the basic structure doctrine, how the Supreme Court devised it, and how it has been deployed by the apex court. Most importantly, its criticism. Let's begin by understanding the basic structure doctrine. Now, the basic structure doctrine laid down in the historic case of Kesav Nanda Bharti is a constitutional milestone. The doctrine laid by the Supreme Court says that the basic structure of the Constitution cannot be changed. If the Parliament, for example, attempts to bring in a law or attempts to change the basic structure, then the court has the power and the authority to strike down that legislation in the interest of protecting the Indian Constitution. Well, simply put, the basic structure of the Constitution cannot be changed. That takes us to the question, what is basic structure? Liberty, fraternity, secularism, right to free speech, democratic values, separation of powers, free and fair elections, judicial review. All these principles and tenets that form the core of any democracy are the basic structure of Indian Constitution. These features are vague, amorphous, and all pervasive in Part 3 of the Indian Constitution, which means that just because a government has the majority on numbers in Parliament, they cannot go ahead and make India a totalitarian state or snatch the powers of the citizen. Well, the emergency era is reminder of such eventuality. Well, as an aware citizen, you may or may not know all about the Indian Constitution, but the chapter called Part 3, which deals with fundamental rights, is the Magna Carta of the rights of citizens in Indian democracy. Now, coming back to the Kesav Nanda Bharti case and the basic structure doctrine, in this historic case, 13 judges of the Supreme Court sat down to decide on Parliament's power to amend the Constitution, heard the case for 68 days and argued by the best legal minds of India at that time. The court laid down the power of the Parliament to amend the Constitution is not unlimited. Just because the Parliament has the numbers, it does not mean that the power to amend is absolute. The court put a check on that power and termed it as the basic structure doctrine. Under this doctrine, any legislation or any action of the government that, in the opinion of the court, violates that basic structure, it shall be struck down. Well, many argued that this is also a case that saved Indian democracy. Kesav Nanda Bharti versus State of Kerala has a context and a political history to it. The judgment was the precursor to the emergency in many ways, and its genesis lie in the series of confrontation between the Indira Gandhi government that time and the Supreme Court of India. The Indira Gandhi government that time had annulled various judgments of the Supreme Court through constitutional amendments that had created an atmosphere of high tension between the apex court and the government. By a wafer-thin majority, 7-6, the Supreme Court held that Parliament's power to amend the Constitution is not unlimited. Who can forget the dark days of emergency when the constitutional rights were suspended and the state machinery turned India almost into a dictatorship under then Prime Minister Indira Gandhi? The judgment of the Supreme Court in Kesav Nanda Bharti made sure that the jurisprudence of the Supreme Court was on the right side when tested during emergency. In fact, during the emergency era, there was an attempt to overturn this judgment that was thwarted by the legal genius and maverick of noted lawyer Nani Palkhiwala. That story for another day. So the judgment of Kesav Nanda Bharti is not some instance where the judiciary grabbed the opportunity to seize power. The case stands as a shining example where the court stood up for constitutional ideals. It was this case that cost Justice H.R. Khanna his Chief Justiceship at the Supreme Court of India because he dared to stand up to a powerful government. Well, is there any evidence to argue that the court has misused the doctrine? the evidence at the very least, if not absent, is clearly scant. Take, for example, the case of Indira Gandhi versus Raj Narayan, where a sitting prime minister was accused of rigging elections. It was this particular doctrine that was used in this famous, or rather infamous case, Raj Narayan versus Indira Gandhi, to hold the 39th Amendment to the Indian Constitution as illegal. Indira Gandhi had brought this amendment to save her election and to keep her seat. This case was also the trigger to emergency. Let's now talk about the objective of the basic structure doctrine. On various other instances, the court has asserted that Parliament has powers to change all parts of the Constitution. But elected politicians cannot betray the vision of the founding fathers of the world's largest democracy. The basic structure doctrine, though, is a judicial assertion, but has roots and history in Indian Constitution. But all is not hunky-dory. In fact, when it comes to the reform of judicial appointments or the collegium system, the Supreme Court is in a tricky spot. All of us know about the 99th Amendment to the Indian Constitution that was struck down. NJAC was termed being violative of the basic structure. But there's a take two. There's a second part of the NJAC judgment that talks of judicial reform, that talks about reforming the collegium system. Promises sweeping changes, but that promise perhaps has not been kept. There's an established legal maxim recognized in law and equity: no one shall be the judge of their own cause. And when it comes to judicial appointments and the system of collegium, roughly 25-year-old, it has shown a keen intent to reform, but little has been done on the ground in terms of execution and making sure those reforms actually happen. The government has made a stinging and belligerent attack for reform for the present system. And in fact, a government representative in the present collegium system is being sought by the law minister. Many oppose this pressure from the government and call it NJAC from the back door. While the criticism from the government is that the basic structure doctrine should not be used as an excuse to keep the power of judicial appointments unchecked. The basic structure doctrine in itself is not a problematic concept. As stated earlier, it has context and political history to it. But the deployment of this doctrine for striking down NJAC has been criticized. Many experts argue that the prevailing mistrust between the government and the judiciary will only delay the process of reform. The doctrine of basic structure is one to be preserved and developed for the times to come. But the institution called the Supreme Court of India that sits atop, which is the final arbiter of Indian Constitution, will have to make efforts to make judicial appointments more transparent and accountable. Not for any government, but for 1 billion+ people and their constitution. Well, with that, it's a wrap. Thanks for watching.